in new CRPC, which is BNSS 2023, it replaced earlier CRPC 1973 from 1st July 2024. So in this BNSS, there is a introduction of new trial in absentia of the absconding offenders. So we will discuss in this video what is the procedure provided for trial in absentia of such accused. So in criminal procedure, there are two types of trial in absence of accused. Inquiry and trial in absence of accused can be of two types in the new BNSS. There was a provision of recording of evidence and trial could have been done in absence of the accused in certain circumstances in earlier CRPC, but one more procedure has been included for proclaimed offenders, the offenders who are evading the trial. So there are now two types of trial in absence of the accused. So first type is that trial in absentia when the presence of the accused is not necessary or he disturbs the proceedings. That court in its discretion, court may dispense with the presence of the accused if his presence is not necessary or he disturbs the proceedings. So then second type of the trial in absentia, which has been included in new BNSS, it provides when the accused absconding and declared proclaimed offender. Now who is proclaimed offender is a different provision. This is second type of trial in absentia of proclaimed offenders. So in this kind of trial in absence, the court can try the offender and at the same time pass the judgment in its absence. So now section 355 of BNSS resembles section 317 of CRPC, in which it was provided that when the inquiries and trial can be conducted in the absence of accused. So the provision is similar to CRPC, but some changes are introduced here in BNSS, otherwise the provision is same. So it provides that at any stage of the inquiry or trial, under this Sanhita, at any stage of inquiry and trial, if the judge or magistrate is satisfied for reasons to be recorded that the personal attendance of the accused before the court is not necessary in the interest of justice. So when the personal attendance of the accused before the court is not necessary, he is not absconding, he is not evading the trial. In this provision, they are saying that personal attendance of the accused before the court is not necessary in the interest of justice. So this is first ground. Second, or that the accused persistently disturbs the proceedings of the court. So this is second ground. In this provision, inquiry and trial in absence of the accused in the discretion of the court at any stage of inquiry and trial, when the personal attendance or the accused persistently disturbs the proceeding in the court, the magistrate is satisfied. Then in that case, if magistrate judge, if the accused is represented by an advocate, dispense with his attendance and proceed with such inquiry or trial in his absence. So whenever the accused is represented by an advocate, the court can dispense his attendance and proceed with the inquiry or trial, and may at any subsequent stage of the proceeding direct personal attendance of such accused. So here the provision is very simple. When the accused, his presence is not necessary, or he is disturbing the proceedings, the judge or magistrate, whoever conducting the trial or inquiry, if the accused is represented by an advocate, the court can dispense his attendance and proceed with the inquiry or trial in his absence, and may at any subsequent stage direct the personal attendance of the accused. So now subsection 2 of the provision provides, if the accused in any such case is not represented by an advocate, in case the accused is not represented by an advocate, or if the judge or magistrate considers his personal attendance necessary. Earlier we read that when his attendance is not necessary, then in his absence the trial can be continuing. But here, if not represented by an advocate or his personal attendance necessary, the court may, if thinks fit, record reasons and either adjourn the inquiry or trial, or order that the case of the accused be taken up or tried separately. So where the accused is jointly being tried, so he can be tried separately in such a case, or adjournment can be given by the court in such case where his presence is necessary. So this is subsection 2 of the same provision. So in this provision, the trial in absence is discretion of the court. It is to be remembered that this is not a mandatory provision that the court shall dispense with the presence of the accused and conduct the trial in its absence. So this is a provision where it is wholly the discretion of the court, not a mandatory procedure. So this was the provision, earlier was the provision. In earlier CRPC, they used the term pleader instead of advocate. So now in new BNSS they have directly used term advocate instead of pleader. This was a change done, and then there has been this explanation added to provision. This explanation to section 355 provides, for the purpose of this section, personal attendance of the accused includes attendance through audio, video, electronic means. So whenever the court is dispensing with the personal attendance of the accused, that includes audio, video, electronic means also. So he will be exempted to appear through audio, video, electronic means also. So this is section 355, where the inquiry and trial can be conducted in absence of the accused when his presence is not necessary or where he disturbs the proceedings. But if he is not represented by an advocate, he or his presence is necessary, then in that case court can adjourn the proceedings or try him separately if he is jointly being tried. So now the BNSS section 356, this is a completely new section added, where the provision is inquiry, trial or judgment in absentia of proclaimed offender. So here in this provision, against the proclaimed offender who are absconding and evading the trial, they can be tried, they can be inquired, and judgment can also be given in their absence. So the subsection 1 provides, when a person declared as proclaimed offender, whether or not charged jointly, has absconded to evade trial and there is no immediate prospect of arresting him, then it shall be deemed to operate as waiver of the right of such person to be present and tried in person. So whenever a person is evading the trial, accused person is evading, and there is no immediate prospect of arresting him, that he might not be found anywhere, and in that case if he is not appearing, then it will be waiver of his right of present there in the trial and tried in person. So and in that case the court shall, after recording reasons in writing, in the interest of justice, proceed with the trial the like manner and with like effect as if he was present and pronounce the judgment. So court shall proceed like that he was present during the trial and can also pronounce judgment. The proviso is also there, that it provides the court shall not commence the trial unless a period of 90 days has elapsed from the date of framing of charges. So framing of charges से 90 days का time elapse हो जाना चाहिए after framing of charges, and then only the court can proceed with the trial. Now further subsection 2 provides that court to comply some procedure before proceeding under subsection 1. So where the charge can be framed and then in his absence trial can be conducted and judgment can be passed, before going for that the court has to comply these conditions given under subsection 2, which are issuance of 2 consecutive warrants of arrest within the interval of at least 30 days. So 30 दिन के अंतर से 2 consecutive warrants issue करने होंगे for arrest of the accused person. Second says, publish in a national or local daily newspaper circulating in the place of his last known address of residence, requiring the proclaimed offender to appear before the trial court. So उसके appearance के लिए एक national या local daily newspaper में इस उसके requirement उसके appearance के regarding publication किया जाएगा. So then it provides and informing him that that is in continuance of condition number 2, that in newspaper it shall be published in newspaper and his presence shall be required within 30 days from such publication. So जब newspaper में उसको publish कराया जाएगा तो ये condition होगी that there must be time period of 30 days within which the accused person must be present before the trial court, and in that case he fails to come within that time period, the trial shall commence in his absence. So this was condition number 2. Then 3 says, inform his relative or friend if any about the commencement of the trial. So कोई relative या friend को inform करना होगा about the trial. So affix 4th says, affix information about the commencement of the trial on some conspicuous part of the house or homestead in which such person ordinarily resides, and display in the police station of which district of last known address of the residence. तो जहाँ पर वो अर्लियर रहा है वहाँ पे उसके घर में या उसके घर के आसपास उसके वो जिस डिस्ट्रिक्ट में रहा है वहाँ पर उस पुलिस स्टेशन में, वहाँ के पुलिस स्टेशन में इसको डिस्प्ले किया जाएगा. सो यहाँ पर ट्रायल में कमेंस करने के पहले ये प्रोसीजर भी ऑप्ट करना होगा. देन सबसेक्शन 3 सेज, वेयर द प्रोक्लेम्ड ऑफेंडर इज़ नॉट रिप्रेजेंटेड बाय एनी एडवोकेट. When he is not represented by any advocate, he shall be provided with an advocate for his defense at the expense of the state. So point here is to be remembered that because this trial in absence of the accused who is a proclaimed offender, the provision says that trial shall be conducted, which means in his absence there is a mandatory provision, there is a mandate that the trial should be conducted when he is waiving his right to be heard. So when he is not intentionally coming and evading the trial, then in that case this provision provides that trial shall be conducted in his absence. So That's why when he is not represented by an advocate, he should be provided an advocate for his defense at the expense of state. So this is subsection 3, very important. And 4 provides, where the court competent to try the case or commit for trial has examined any witnesses for the prosecution and recorded their depositions, such depositions shall be given in evidence against such proclaimed offender on the inquiry into a trial for the offence for which he is charged. So this is the provision where whenever the witnesses are of the prosecution and their depositions are recorded during the trial, those depositions shall be evidence against the accused person is in trial. So this is subsection. Now there is a proviso which says, provided that if the proclaimed offender is arrested and produced or appears before the court during such trial, the court may, in the interest of justice, allow him to examine any evidence which may have been taken in his absence. So this is a proviso when during trial, when the trial has already begun but the accused person comes before the court, and in that case court may in its discretion, in the interest of justice, usko allow kar sakta hai that you can examine the evidence. Now subsection 5 provides, where a trial is related to a person under this section, where a trial is related to a person under this section means the proclaimed offender, the deposition and the examination of witness may, as far as may be practicable, be recorded by audio video recording, electronic means, and preferably mobile phone, and such recording shall be kept in such manner as the court may direct. So the provision says that when the accused himself is absconding, then in it case it will be very comfortable for people who are witness that their evidence can be recorded by through audio video electronic means. So this is a mandatory and kind of not mandatory, but then as far as practicable the term has been used. So it is the provision when the accused himself being a proclaimed offender, in that case if the witnesses are there, then their evidence should be recorded through audio video mode and preferably mobile phone. So this is a completely new provision when the accused himself is not appearing, and this is a good provision that even witnesses should be, their evidence should be recorded through audio video mode. So this is subsection 5. Now subsection 6 provides absence after trial has begun. So when the accused was already there but he suddenly disappears and gets absent when the trial has begun. So subsection 6 provides, in prosecution for offences under this Sanhita, voluntary absence of accused after trial has commenced under subsection 1 shall not prevent continuing the trial, including the pronouncement of the judgment, even if he is arrested and produced or appears at the conclusion of such trial. So when he is absconding after the trial has begun, it shall not prevent the continuing the trial, including the pronouncement of judgment, even if he is arrested and produced or appears at the conclusion of trial. Whenever the judgment has been pronounced, then there is a provision of appeal, but this provision subsection says that no appeal shall lie against the judgment under this section unless proclaimed offender presents himself before the court of appeal. So for appeal, the accused must be personally present before the appellate court. Only in that case he can proceed with the appeal. So his personal appearance is necessary whenever he is appealing the judgment on the trial which was conducted in his absence. So the proclaimed offender must be there before the appellate court personally to proceed with the appeal. So this is subsection 7. No appeal against conviction shall lie after the expiry of 3 years from the date of judgment. So under this section, whenever the trial in absence of the accused has been conducted, an appeal must lie before 3 years from the date of judgment. So this is the proviso of subsection 7. In Bharatiya Saksh Adhiniyam, section 24 is there, which provides that it provides for joint trial. So there is an explanation which says there is a deemed joint trial when accused is absconding or who fails to comply with the proclamation, and there are some other co-accused persons, and there is a joint trial. Then even if one of them is not present there, he is not appearing, then it shall be a deemed joint trial amongst those co-accused persons, all of these accused persons. So this is a explanation added to section 24 of Bharatiya Saksh Adhiniyam for this trial in absentia, which says that even if one of the co-accused is absent and he is declared absconding proclaimed offender and his trial is being conducted in his absence, then even then the trial shall be deemed to be a joint trial. So very important. Now it is very important to understand who can be the proclaimed offender. Every offender is not proclaimed offender, and who is proclaimed offender we must understand the provision, its object. So the section 84 and 85 deals with the proclamation and attachment of property when the person is absconding. So section So section 84 of the BNSS provides that then whenever somebody is the accused person is absconding, there is a provision of proclamation, which is a separate provision not related with our today's topic, but the how when a person can be called as a proclaimed offender is provided in this section. So if you see subsection 4 of the section 84 provides where a proclamation published under subsection 1. So subsection 1 provides for proclamation in respect of a person accused of an offence which is made punishable with imprisonment of 10 years or more, or imprisonment for life or with death under the Bharatiya Nyaya Sanhita 2023 or under any other law for the time being in force. Such person fails to appear at the specified place and time required by the proclamation, the court may, after making such inquiry as it thinks fit, pronounce him a proclaimed offender and make declaration to that effect. So interestingly, not every person who is absconding and against whom a proclamation has been published under subsection 1, not every accused is to be called a proclaimed offender, cannot be declared as a proclaimed offender. Only accused of an offence which is made punishable with imprisonment for 10 years or more, or imprisonment for life, or with death. So only in those cases a person can be declared as a proclaimed offender, and then trial in absentia under section 356, as we earlier discussed, can be conducted. So we have to remember this provision, subsection 4 of section 84, very important. Now there is a legality and difficulties of trial in absentia. What are the difficulties? First difficulty is that there is a violation of prima facie, there is a violation of second principle of natural justice, which is odi alteram partem. But to understand this, that the principle is practically is not violated in this provision. Reason is that he is given opportunity of hearing, he is not denied of opportunity of hearing. In fact, when we are calling the accused person to appear and give, and you must speak of something in defense of the charges which are proposed against you, and in that case the accused is not appearing. In that case, it is the provision that waiver of this right to try in person, the right to be heard, has been waived. So this is to the object is speedy trial, and whenever there is a delay in trial, there is a threat that the accused person might be dissuading the witnesses or tempering the evidence. And in such case, to avoid these circumstances where there is a long delay in trial, there is a when the court is bound to give unnecessary adjournments when the accused is not appearing, because earlier there was no provision of trial in absentia or absentia of the accused persons. So the provision says that it does not violates the trial, the principle of natural justice, that accused person has right to appear and give a proper explanation, he is right of hearing. But in cases where he is being sent warrants and he is not appearing, in that case the provision says that he waives his right. So this is a waiver of right, not the violation of principle of natural justice.